Hey YouTube family and GN subs, how are you? Hope all is well. And we got some good news updates today. For those of you who are new to the channel, I am the good news guy, right? What I do is give you good news. I give you new policy that's happening with immigration. We have some real important policy today. We have a new law. We have new policy memorandum regarding EB5, regarding EB1 extraordinary ability petitions and a standard, etc. We have a great update on TPS, got a great settlement from USCIS. We're going to go through all that today. A lot to unpack. Those of you who are new to the channel, my name is Humberto Gray, Attorney at Law, here on the West Side, Los Angeles, California. It's sunny today, man, and I'm feeling good. I'm ready to go. All right, so we got a lot to unpack. Let's get at it. All right, first bit of good news. So they have extended again the time to respond to RFEs, notice of intent to deny, notice of intent to revoke, an appeal both from petitions, I-130s, I-140s, to citizenship denials. So now here is the good news. So it's been extended. Any of these notices that are issued now out until July of this year, 2022, you have additional time to respond. We've talked about this in other videos. I'll go through them quickly. So for the NOIDs, the notice of intent to revoke, deny, etc., RFEs, you have 60 additional days from the due date. So you look at the due date, add 60 days, you're good. On the appeals, you have 60 days from the date the decision, the denial was issued, all right? So usually on the denial of petitions and citizenship, you have 30 days to appeal. So now in essence, you have an additional 30 days, right? So instead of 30 days from the date it was issued, you have 60 days from the date it was issued. All right, so that's great news. All right, EB5 stuff. So Biden signs the EB5 Reform and Integrity Act of 2022, brand new law, folks. So what's happening is regional center petitions, right? You have regional center petitions. We have been waiting for the reauthorization of that regional center petition. So if you made an investment of $500,000 as opposed to $1 million under the normal investment EB5 program, you've been in limbo. You've been waiting. Your petition, even if it's been approved, adjustments pending, it was a mess, right? We've been waiting. So this law finally signs for regional centers. Regional centers are good now until September of 2027. That is great news. I myself helped with the regional center in Fresno. We've capitalized so many companies with EB5 money. We had almond farms, grape farms. We have an operational winery. That's our last investment. So you invested $500,000. You get a green card in essence. So some of my clients that was on the latter end, because it wasn't reauthorized, it was kind of not moving, but now it's moving. We're gonna get the green cards. That's great news, new law. So what does this new law do? I'm gonna go through some major points, just some major points, right? So as I suggested, it extended regional center petitions out until September 2027. You can continue to file those. The investment amount in the regional center has gone up, right? So from $500,000, which was the original investment, it is now $800,000. So that's a major change. On the normal investment EB5, it was $1 million. Now it's $1,050,000. Didn't go up so much. Good news, right? Good news for normal investors. A really bit of good news. So if you're filing a petition, certainly for India and China, where there's long waits, to get the petition approved and then for the visa bulletin to become current, they are allowing concurrent filing of the I-526 and the I-485. That means initially when you make your investment, you're going to be in status. You can change your status here in the US. That is a game changer, folks. Certainly, again, for the Chinese and the Indians, where there's always problems with the visa bulletin in that category because they only allow so many in per year, and there's a lot of applicants from those countries. Another bit of good news, there's been a lot of fraud with promoters and agents that are overseas. They get these foreign investors and they charge them tons of money to help and assist in these petitions, which is horrible. They're taking advantage in the program. So the new law says they must register with USCIS, who's going to keep an eye on these folks. So that's good news. All right, another bit of good news. There has been a settlement. Immigration Lawyers Association and Caresen, that was the group that brought this suit. They are awesome. So they finally made a settlement. So if you have TPS, temporary protected status, so this is the new status now, certainly like for many Ukrainians that are here in the US. So if you're here in the US, you're on TPS, you get advanced parole, you leave the country, you come back in, that is a legal admission and inspection. You can file an adjustment of status if you have a way to do that. Now, if you had a prior removal order, you weren't able to file the adjustment. The lawsuit mandated a settlement, and the settlement is that if you have a prior removal, that's a deportation order, right? So USCIS wouldn't have jurisdiction over your case to file an adjustment if you were one of these TPS recipients. What happens now, they have stipulated that they will reopen the removal proceedings and terminate proceedings. So now USCIS can have jurisdiction. You can file your adjustment and get the green card here in the US. Really good news for TPS recipients. All right, we have some good news in the EB1 category, right? EB1. So individuals with extraordinary ability in science, art, business, athletics, that is the category. What's been happening with USCIS, we have had horrible decisions on 2 criteria. So to really quickly recap, you need to meet 3 to get the green card petition approved. It is a self-petition. So 2 of those criteria, immigration has been narrowly interpreting the regulation. One is you can serve as a leading role in a critical organization. And what they say is that, so if you're serving in this role, it has to be for the whole organization. It can't be for a department or a division, which is huge. Now they've made clear in this policy memorandum, I put a link in the description box below, it can be a department or division that you can serve as a leading critical role, okay? Published materials is another criteria that they interpreted very narrowly. They said that the material had to be in a printed source, right? Couldn't be a video or audio. Now they've extended it, made it clear, yes, it can be a transcript of a video or audio. That opens up the category quite a bit, and evidentiary information that you can provide in connection with your application. Great news, all right? Let's talk about some real-time cases, folks. So this is in connection with work authorizations. Look what I'm seeing. Quick adjudication, folks, quick adjudication, the new policy that I've been talking about time and time again, where they're trying to get rid of the backlog for work authorization, right? Look at this one, less than 30 days, approved. Look at this one, 45 days, approved. 2 years now, right? They're issuing for 2 years. So that's great news, folks. File your work authorizations. Hey, YouTube family, thank you so much for all your birthday wishes. Click below, like and subscribe. Hey, 4.5 million views and up to almost 60,000 subscribers. Thank you so much, and we'll see you next week.